So let's get going with question 1. So what are trustees' fiduciary responsibilities in South Africa? Let's get straight into that.
Okay, I'm going to take the first question because it gets it over and done with. I think I think in South Africa, what we've got to recognize is what is a trust, which is it's really a contract between a person, which you can call a founder or a settler, with the trustees to look after assets on behalf of a third party being beneficiaries. So the trustees have got a really important role of having a custodian. They've got custodianship over assets which do not belong to them, but they have to act at all times at the best interest of their beneficiaries. So it's if you look at their responsibilities are largely they're largely there to make sure that the beneficiaries' needs are met. And in order to do that, there's a Trust Property Control Act that puts a whole lot of responsibilities onto the trustees, including things which are fairly onerous, like opening bank accounts, keeping a good set of records, making sure you have meetings. These days, you have to make declarations to the master's office on beneficial interest. There's a whole lot of responsibilities that you have to do, and I know, because I'm probably one of them. I know we're not doing it particularly well. It's what happens is that we've taken up trusteeship positions, and often these things lapse where you actually haven't been fulfilling your duties 100% accurately. And I think what's happened is we've gotten away with it in the past, but I think things are moving into a direction that is becoming a lot more uncomfortable.
Okay, so can I just be clear? So the trustees' responsibilities are towards the beneficiaries of the family trust.
Or whatever trust. So they're
Any
basically
trust.
Any trust. So you could have a trust that's set up for employees. But their responsibility is to act in the best interest of those employees. So, and there would be within the trust deed, which is the document that drives everything, that it will specify what the actions, what the trustees can and can't do. But overlyingly, it needs to be done. Whatever they do cannot be for their own benefit. It must be for the benefit of the beneficiaries.
Okay. And what happens if the trustees fail to do this?
Well,
and sorry, can I just add to that? How will the beneficiaries know
that they failed? Well, you see, at the moment, it's the trust, and I think the trusts have been a poorly regulated entity. I think if you look, what happens is people, it's fairly easy to form a trust. You basically draw up a trust deed, you lodge it with the master's office, and then there hasn't been really any regulations after that. Whether you get registered with SARS, whether you open a bank account, what happens thereafter actually is largely it's not monitored particularly well. What we found, or what happened is a couple of years ago when we had the report on the grey listing, that was one of the major issues, is that they said that we had unregulated trusts. There was, from a trust point of view, people couldn't really determine who the beneficiaries were, and they were largely badly regulated. Now, the thing is there are fairly severe punishments that are available to the master if you do things wrong. Largely, there's fines that can be imposed up to, I think the amount is 10 million rand, which is a bit scary. There is imprisonment if it's a breach of your fiduciary duty with an element of criminality. So if you stole some of the money, well, then you're going to go to prison. So there are severe sanctions against it. But what actually you learn every day. And I had a training session this morning, and the question was asked: how does South Africa get out of the grey listing? the person wasn't particularly optimistic that we will get out the grey listing shortly, largely because there's been no prosecutions and there's been no in respect to the transgressions against the items that have been found to be where we were found to be deficient in the grey listing documentation. What happened is there's been no discernible action taken by the authorities, and until that is done, we won't be taken off the grey listing. And one of the issues that they've actually highlighted is the lack of clear beneficial interests in a trust and the administration of trusts. So until the regulators start regulating this a lot more aggressively, and actually be seen to be doing that, it's going to prejudice our grey listing. So I think that's going to happen, and it's going to happen fairly soon.
Okay, and
But I think, Ange, maybe
Sorry.
just to add a bit more to your question, and it's a good question. The intent is clear from the regulatory bodies, is that these trusts are now under scrutiny, and it's a matter of timing before there is a form of consequence. But to answer your question directly, how do you know if you're doing a poor job? You don't. And I think that's the challenge at the moment, is that we're on the brink of this thing really being brought to the forefront because of the grey listing, and it's going to come at us quickly. And I think the majority of trustees out there are highly unsuspecting trustees that aren't aware of their fiduciary responsibilities, because nobody's doing anything, and it feels all right at the moment. But yeah, you actually don't know what you don't know at the moment. You don't know whether you're doing a poor or a good job.
And who is monitoring or governing these trusts?
Well, the trusts fall under the ambit of the Master of the High Court. So
Okay.
so if you look generally, if you looked at how it's been, the only time you really saw trustees getting into trouble is where they've done something where the beneficiaries have been prejudiced or felt they've been prejudiced. So they will approach the master and say, look, they want the master to review the actions of the trustees. So that's largely been the trigger. But if there's no beneficiaries putting their hands up and saying, look, something's going wrong here, largely nothing gets done. So I think what needs to be put in place is a framework where there's reporting requirements to the master's office, and if you don't do that, well, then there will be consequences. So I think that has been put into place at the moment.
Okay. And does this also include reporting to SARS?
Well, so SARS is always lurking in the background on whatever you do. So what happens is that there's, at the moment, there isn't a clear link between the master's office at SARS. Unlike the CRPC, which is if you form a company, SARS is immediately informed and you're registered for tax immediately. That doesn't happen at SARS with regard to the master's office, but I think that will be coming soon. But what we're finding is that from a SARS perspective, the requirements in respect to reporting who the beneficial owners are of the trust, and also reporting what income has been accruing in the trust, is becoming more and more onerous and more. It's the volume of information that they're obtaining on an annual basis is probably 100 times more than what they were 2 years ago. It's chalk and cheese, where a tax return for a trust used to be 2 pages. It's now could be anything up to 30.
Okay.
So
these are the recent changes that have been made.
That's if you look
to
at
the taxation of trusts, right?
You don't see any happy tax consultants or tax practitioners anymore, because they spend their life filling in trust tax returns, and it's just information. It's just capturing data.
Right. Okay, that sounds exciting. A job that everybody wants to do, I'm sure.
Everyone wants to be a tax.
But you guys want to do it, correct? Okay, that's good to know. So so about talking about changes to taxation, and I think clear reporting towards the beneficiaries and other trustees, I would imagine that is it one person's job to do this? Is one person declared the main trustee, the head
You've hit the
trustee
nail on
that
the
gets
head.
to
There is a main trustee,
Okay.
but you have to actually make now a declaration to SARS who the main trustee is.
Right.
That's the person I think who'll get sacrificed.
Yeah.
But there's what you'll find is in every trust, or most trusts, you'll find that there are trustees who have got almost a direct or indirect link to the founder of the trust. And they're looking after the family interest. So if you set up a family trust, you might have a family, or you might have family members who are trustees, but you'll always need one independent trustee whose
Right.
job it is to make sure that that everything is toes the line, and and the responsibility of that independent trustee is largely to make sure that these type of things, these requirements are actually adhered to. Largely because that person should have they should have the abilities and to be a trustee, whereas some of the other trustees might not have full knowledge of the law. They might just be they might have more interest in the beneficiaries rather than the application of the law.
Okay. So let's talk about a very hot topic right now is the termination of trusts, and not how would you do it, but why, for what reason would you need to terminate a trust?
I think there's one or two. I think there's also, to start off, we need to look at why people form the trust.
Yes.
So if you looked at a trust, often there's two types of trust broadly. There's an inter vivos trust and a testamentary trust. Testamentary trusts are formed on the death of a person and are really a part of the will. Often they have got a sunset clause in them, so they might say, "Look, we'll form a trust when the beneficiary gets to 25 years old. The trust will be terminated and the assets will be distributed to the beneficiary." So those trusts terminate by application of what's in the trust in the trust deed. So what happens is those die, and no one does anything. So they still lurk at the master's office, and no one really actually does anything to take them off the records. The other reason is because the trusts themselves just stop serving the purpose for what they actually were set up for. So either the primary assets get sold, or more and more recently, what happens is the beneficiaries move overseas, and the whole functionality of the trust becomes a lot more problematic. And if you look at the trust, the trust actually stops serving its purpose of either protecting the estate of the founder of those assets, or becomes a very, very expensive conduit to get income through to those beneficiaries. So what happens is that you look at it and say, well, this trust doesn't actually serve the purpose that it was set up for, and then the decision is how do we terminate it?
Right. So that's the big question. So
yeah.
Do you think that a lot of people are under the impression that if I've now inherited the assets of the trust is no longer active, should we say? Do they realize that they have to go through a process of closing the trust, or terminating it, as you say?
Yeah, well, it's. I think a lot of people don't know that there's that they have to do, because technically, from a legal point of view, once the assets have been distributed, the trust actually ceases to exist, because there's if you look, the whole purpose of the trust is for the trustees to administer assets on behalf of beneficiaries. If there's no assets, there's nothing. There's no purpose behind it. But it's just the admin of terminating it with the master's office and with SARS. If it's not done, you'll start the reporting requirements will continue until you actually physically tell them to stop. So the problem is that you'll start getting nasty letters from both the master's office and from SARS SARS will say, please come here with tax returns. Master's office will say, we want an annual declaration of your beneficial interests. And you'll keep getting it until you actually do something about getting rid of that trust.
And that's where you guys come in.
We are, I think, we are trust undertakers. That's we look at, and the real, if you look at the driver behind our business, was largely because it's a job that no one really wants to do. It's not particularly pleasant. And what Alan has done very effectively is he has streamlined the process. So we made it as automated as we possibly can. Try to take a lot of the stress out of terminating the trust. So we take on all the responsibilities. All you have to do is give us information, and we'll sort out the termination. But it really is not. It's not a pleasant job. But it's somebody has to do it. So so we thought, well, we might as well fill that space, because no one else. It's a space that is going to become more and more important.
Yes. And can people do this or apply for you to do this for them through your website?
Yeah, and there's two different ways to do it. But if we just speak about the man on the street, not so much a financial advisor who just wants to do one,
Yes.
you can log onto our website, which is LEMS Systems, lemsystems.co.za. We've got a payment gateway there. The trigger to get the process going is immediate. As soon as you register, we'll get hold of you and hold your hand through the process. As Brian correctly says, a lot of it is automated. And then the real laborious, onerous part of the process, dealing with the government officers, that we handle completely independently once we've got all the documentation from our clients.
Okay. And can I just ask a question? What if the trustees are deceased and the beneficiaries are still alive or overseas, let's say? What now happens to this trust?
Well, maybe I can give a good example of one of our trusts that have recently we've just submitted through to the Master's Office. It's a trust which is exactly 30 years old. It started off it's actually a bit older now, in 1994. The one trustee, who's a hugely responsible fellow, understands his fiduciary responsibilities, can't scoop together the rest of the trustees. It was a school trust. Some of the trustees have deceased. Some of them have just disappeared unknowingly as to where they've gone. And it's a real onerous position to be in. So yeah, I mean, those are the types of trusts that we do have. And in an event like that, where people or our trustees or clients are at a loss as to what to do because of missing people, missing documents, that's really where we come in. We sit together with you. We look at the exceptions around your particular trust, what documents you have or don't have, who's around, who's not around.
Okay.
And we draft the letter to the masters and take the process from there.
Okay, so you can take on anyone that's involved in a trust. We don't have to be wanting to close it down.
So far, so good.
Any help that you need with the trust, I think these are your guys.
Well, if you look at, often it's just a case of getting the ship back on track, because you in every trustee that regulates how many trustees, every trustee regulates how many trustees you've got. It's a case of reading the trustee, because it also regulates as to how, with the process of appointing a new trustee. So it's really a case of being, there's normally, hopefully, one trustee who is now feeling a bit nervous and isolated because the rest of them have fallen out. And really what happens is we'll lead that trustee through the process of actually getting it back on track, and either then terminating it or seeing if he could actually administer it properly. When it comes to the administration of the trust going forward, we normally don't try and tread on any other financial advisors' turf. So we'll encourage them to continue to use their accountants or their lawyers who they're using. But it's really sometimes just a case of just getting them back on an even keel.
Okay.
And I think, Ange, the big thing is to keep these things moving.
Right.
There are lots of instances with trustees who have tried to close their trust down. And for a number of reasons, the process normally grinds to a halt because of something that's missing, either a document, a piece of paper, or they just can't get hold of someone, and these things stall. And really, that's the joy of our process. Once we've got you onto the track, we'll keep it moving through to closure.
Okay. So we've got some questions coming through. Let's go to the first one that says, when can the termination of a trust be justified?
Well, I think there's always a cost benefit to a trust. So if I looked at a trust and said the benefit of a trust, and if I looked at it bluntly, from a tax perspective, there's an estate duty benefit to a trust. So if you've got assets in a trust, it's effective with regard to actually keeping those assets in the trust, because the person who put when they die, it falls outside of the estate. But if all parties have now moved offshore and are living overseas, well, it doesn't matter if the person's alive or dead, because he's not going to be subject to estate duty on his assets in South Africa, other than potentially some assets situated in South Africa. So normally the assets start to be wanting to be moved offshore, and it becomes very expensive from a tax point of view to keep the assets in the trust. So I think my thoughts are that the biggest driver at the moment is where the beneficiaries are sitting offshore, because the tax cost will often outweigh any form of benefit of having that trust.
Wow. Is that because they have to pay in foreign currency, or wherever
No,
they are?
it's just because there's a high likelihood of double taxation, because
Okay.
in certain jurisdictions the tax law is very different to ours. So what happens in South Africa is the tax law says if I earn, just say, rental income in South Africa in a trust, and I distribute it to a non-resident beneficiary, that's going to be taxed in the trust in South Africa at 45%. So that now we lose 45% of the tax. The problem is it's taxed in the trust. So the trust is the entity that gets taxed. The person is sitting overseas, for instance, if we look at Spain, that person, they don't regard trusts as, they don't recognize trusts. So they'll say that the individual would have earned that rental income and will be taxed on that. That income at whatever the tax rates are now at Spain, and you can land up with double tax. So I think it's a case of then you'd look at it and say, well, what's the benefit of having this trust? Is when the country that you actually are living in is not going to regard it as a protective entity in any event. So in those cases, then it really becomes a decision as to whether you need to keep it or not.
Right.
And Ange, obviously there are costs
yes.
as well to fulfill your fiduciary responsibilities. There's a cost, there's a hard cost and an intangible cost of administering a trust and keeping it updated every year, fulfilling your obligations. And if there's a limited benefit to keeping it open, just to have this ongoing cost just doesn't make sense.
Right. Okay. So we've got a question here from Karen, both are attorneys. It's quite a long question. I'm going to read it for you. Thanks, Karen, for your question. What would you suggest in the following scenario? The trust has 2 trustees and 1 beneficiary who is not a trustee. The trust owns a property which is a guest house. One of the trustees stood surety for the bond on the property. The beneficiary has taken control of the letting of the property without consent of the trustees and is withdrawing monies earned by the guest house from the trust's bank account, and at the same time is not paying the bond. One trustee is refusing to engage with the other trustee. Wow.
This is a mess that can happen. generally what happens now is my thoughts is in those type of circumstances you seek relief with the master of the High Court, because basically what you've got is a dysfunctional trust. Firstly, you've got 2 trustees, which is never ideal. It's always better to have 3, because you need
Right.
2 trustees. You're going to hit a stalemate periodically. Secondly, you've got one beneficiary, and he seems to be under the impression that the assets are his, whereas the assets actually belong to the trust. So the control and the control of the assets needs to be reestablished with the trustees, and there's a misunderstanding as to who's in control and who's calling the shots, and I think that
Right.
needs to be reestablished quite clearly. And my recommendation would be to also get an additional trustee.
Trustee.
If the trustee permits it, which it should do, I would get another trustee appointed in that trust.
Well, the trustees are now not speaking to each other, it seems. So maybe
It's
a legal
it's-
matter.
Yeah, what happened? I've
Shame.
had this before where beneficiaries have been at loggerheads, and generally what happens is the master does step in and will give instructions to the trustees on how to resolve the matter. So
Right.
the port of call could be to the master's office and say, look, this set it out in writing where the problem is, and because it falls under the ambit of the High Court, they can give instructions as to how to resolve the problem.
Okay. I hope that helps you, Karen. The next question is for Ellen. Ellen, what did you do to streamline the process? Ellen,
you're
you're on
mute,
mute.
Ellen.
Sorry, thank you.
Okay.
And yeah, it's largely about paperwork. There's various elements of or documentation that have to be assembled in order to put a submission through to the master's office, starting with the master's office, and potentially, depending as to how the trust is registered, potentially with SARS as well. But because it's largely a paper collection and a paper chase, the automation that has been created is through a set of questions which get filtered into a database, and a number of different permutations exist, which we create. Effectively, it's a mail merge on steroids, which really creates a draft to the master's office and a set of instructions as to what documents are needed, which ones are originals, which ones are copies, etc. But it's really largely automated, but it is a tailor-made approach relative to circumstances. We find probably falls 50-50 where it's highly automated and a trustee's trust is closed very quickly. And then in some cases where the trusts are older and more complex, they take longer, and the automation plays the initial part of the trust closure with generating all the templates and all the documentation. And then the rest is consulting and just trying to work out as to how we overcome some of the stumbling blocks.
Each case is different, right?
Yeah, each case is different. You know, we talk about 16 permutations. They all fall within 16 fairly clear buckets. And then depending on a number of different variations within those, there can be some nuances, but generally there's 16 main permutations that we work with.
Okay. Well done, Al. So can trustees in sectional title be sued? There's an interesting question.
Trustees, so I'm just trying. If I look at a sectional title, because generally there'll be a sectional title itself would be a separate entity which wouldn't per se be a trust, because you'd have a board of some nature who would be looking after that, almost like a body corporate looking after that sectional title. Now from a point of view of their duties would largely be set out in the Sectional Titles Act. So can you be sued if you're part of the board and you're not adhering to those duties? Well, there would be recourse against you. From a trustee's point of view, you very much can be sued. But the suing in most of the cases that I've seen have been in relation to not looking after the assets to the best interest of the beneficiaries. So, for instance, if you start blurring the line between what is your assets and what's the beneficiaries and what is the trust, well, then you're going to get sued. Or if you start prejudicing one beneficiary over another one, so if you like the one more than the other, and often in these trusts, the trustees have discretion as to who's going to get what. So if you start being unfair, I think you can be sued by the beneficiaries.
Okay, so I think that's two questions. Are you a trustee in a sectional title establishment, like part of the body corporate, or are you a trustee
in the normal sense of the word?
Yes. Okay. So thanks. I think you've answered both of those. And I think, and the next question, we did address it before, but if you can just go over that again. So why does a trust have to be formally terminated if it has no assets?
Well, it's because I think in the past, quite honestly, no one really worried because it didn't have any real implications. No one actually would send you any rude emails or letters saying you've got to do something. What's happening with this trust? I think what has been the driver, and we did mention it, is this grey listing, where now beneficial ownership of the trusts have to be reported to the master's office, and from their perspective, they've got to keep a far better eye on what's happening with these trusts. So I think what will happen is it's not going to be so much. It's really just to keep the master's house in order. They can't administer and oversee the operations or administration of thousands of trusts, a lot of which are no longer actually functional, and they have to clean up their house, and therefore the process to terminate it has to actually be followed through, because otherwise they don't know, they have no idea as to whether the person is, for instance, laundering money through the trust or taking money from illicit trading. They've got to have some form of control over who's actually dealing with these trusts. And if they don't start enforcing that, I think firstly, I think they'll get into progressively more trouble. So I think what's going to happen is the trouble is going to flow down to the trustees, and they're going to say, look, if you're not in existence, you got to tell us, otherwise we're going to have to continually bug you in order to actually determine what you're doing.
Yes. So you can't just leave it dormant. It either has to be.
I think we have been in the past, quite honestly. I'm sitting on my desk. I think if you look at it, if I'm honest, there's 6 trust deeds that need to be killed. They've been there for a while. Luckily, Alan can now kill them. So
I was going to say, pass those files to Alan. There we go.
No, it does. But I think every accountant has got a couple of these dormant and trust sitting on their client base, that really we want to get rid of them, but we just, because no one has been chasing us, we haven't done anything about it.
Yeah. Okay, so it was kind of ignored a bit, and now it's become a huge issue all of a sudden, and now it all must happen at once.
Yeah, well,
that's how it happens, right?
I do think this grey listing is one of the catalysts of it, and suddenly, and it's going to get just progressively worse. I think the first problem we had is we all had to now register the beneficial ownerships of the trust with the master's office, and also with SARS. I think the tax return, the requirement was massively onerous. to do it for the first time last year. Now,
Right.
but they've now got that information. So all these trusts have now got, it's now fresh information at SARS and at the
Okay.
master's office. I can't believe that they're going to leave it there. It's going to be, the next step is going to be to see what these trusts are doing.
Or take action if you're not doing anything
Yeah,
about it, right?
and I think that's the thing, is there's going to be somebody who's going to be the scapegoat, who's going to be hung out to dry in order to actually warn anyone else to actually clean up their house.
Yes.
So I think that
So don't be the example.
that's exactly it. Don't be the one,
Okay.
the sacrificial lamb.
Right. Okay, so next question. What happens when nobody wants to take responsibility as a trustee now that you don't have any assets or have any trustees left? Or so the trust has been abandoned. Nobody wants to shut it down or take responsibility for the trust. Now what?
No, that's a real problem, because there's no one to pay our fees.
Exactly.
That's
Yes.
So my thoughts is there must, because if there's no, there has to be a beneficiary somewhere along the line. But my recommendation is somebody has to go to go to the master's office and actually start the process of because those type of trusts have got nothing. There's no letters of authorities. There's no trust deeds. All you know that is that at some stage you were a beneficiary of a trust, but you need to go and find out what the master's office has got,
Right.
which is
Can Alan help with that?
Well,
well,
I'm just thinking, Ange, that the question is what happens when nobody wants to take responsibility as a trustee. The deed of trust is clear. You are responsible.
Okay.
So you just hope you don't get tracked down. But generally, what we find, there's one responsible trustee who does put up their hand. But it's an interesting questioning. It's an interesting question that's being asked. If nobody takes responsibility, it doesn't change your fiduciary responsibilities.
Yeah.
Just because you don't want to take the responsibility, you have been charged the responsibility. And I think that's the scary thing. There's so many non-active or inactive trusts out there where people are in a state where they think, well, we're just not going to take responsibility. You really can't do that. You're accountable for either administering it correctly or getting rid of it.
Right.
you know, it's a really good question, because I think part of the answer is that we don't know what is going to happen in the next couple of years. I think if I look, one of the primary reasons why trust gets abandoned is because everybody's now sitting in Australia. There's a trust lurking in South Africa, and no one's particularly worried about it. No one's done anything, and they say, well, it doesn't matter. I'm sitting in Australia. What can anyone do? And that's a good question. But at the back of my head, I'm looking and saying, but communication is the one thing that has got better and better in time. And if the South African authorities have a look at a list of beneficiaries and says Brian Payne's now sitting in Australia, and the authorities send a letter to the Australian authorities and says, look, Brian Payne's not compliant from a South African perspective. I can only foresee that there will be repercussions on the Australian whatever countries
Right.
start. So I think that's what's going to happen. I think I don't think at the moment there are hundreds of these abandoned trusts. What is going to happen with them is the golden question, or the $1 million question. But I do think I think it's naive to think that nothing's going to happen. I think the rules have changed, and I think what's going to happen is if you were a trustee, you will be tracked down, and somebody will actually start asking you to report on those trusts.
And as we know from our friends SARS, they're not shy of a penalty. So
No.
We're not going to get away with nothing at the end. So best to address it as soon as possible, I would say.
Well, so one of the things that they haven't actually they haven't imposed, not I must actually check, but they don't impose administrative penalties on trusts as yet.
Okay,
Um, but once they do that, then you can be looking at a penalty on every trust return that you haven't put in, and they charge it on a monthly basis. So that starts to add up. And I don't know if it's recoverable because but once you've got SARS on your back, if they never go away, and I think it's something you if you want to sleep at night, you better fix. You
right.
need to fix it, otherwise it will never
Yes.
go away.
So fix it sooner rather than later
That's
is
I think it's
key.
that's our message. I think is really
Right.
we have been a bit complacent. Is really just take ownership of that and start getting cleaning your house. And if it means terminating the trust, well, let's do that.
Right. Okay.
But I think,
Okay, one more question.
if we were to take
Sorry, Al.
if we were to take a guess as to where we think it's going, in October 2023, they promulgated a change to the Act around fairly draconian penalties. As Brian said, it's 10 million rand and five years in jail, which are the maximums. The tax indabas, lots of conversation has gone around around trusts, and the correct or appropriate administration of trusts. And the silence the silence at the moment sort of makes you wonder what they're up to. And as Brian says, all they need to do is to take one or two prominent individuals or trusts, and to make an example of it and say, listen, guys, the legislation has been out in the market for well over a year. We've been talking about it. And maybe that's the way they'll start enforcing it. But the intent is clear. At some stage, they are going to start enforcing it.
Okay. It's coming. So the warning is
Yeah.
out.
Just one thing, I think it's fairly indicative of the state of trusts in South Africa. If you look at an offshore trust, and you look at the trusteeships of offshore trusts, and if you took the remuneration that trustees charge for the administration of the trust in an offshore jurisdiction, it is materially different to what they charge in South Africa. So if you looked at a trustee might charge 10,000 rand in South Africa, it will be 20,000 pounds in an offshore jurisdiction. Now, it's the one thing is well, they do charge more, but the other part is that they're taking it more seriously. I think that's one of the things that you often hear from clients. The trustees overseas are a real pain. They don't take. If you ask them to do something, they'll push back and tell you that you can't do it. They generally are often painful people to deal with because they are doing their job properly, and they charge you for doing their job properly. In South Africa, we do it almost as a gratuitous because we quite like the person, and nothing gets done because we're not getting paid for it. And I think that's the whole seriousness of trust needs to be relooked at. And if you do take on a trusteeship, you need to do the job. You can't get to the end of the year and say, look, I've done nothing, because that's not discharging your duties as a trustee.
Right. Okay. Okay, so here's a good question. What disqualifies you from being a trustee in South Africa?
Number of things. If you go, I think.
You look like you like that question, Brian.
Well, it's bringing back my I think a law like law 1 on trust going back many years. What disqualifies a trustee?
Yeah.
Mental incapacitated. So if you're mentally incapacitated, that will disqualify you. If you are sequestrated, that will disqualify you. There are certain people that shouldn't be trustees by reason of their relationship with the beneficiaries. But if you looked at the two main reasons is that you're mentally not capacitated to actually act in that capacity, but or that you that you've been sequestrated, and generally you'll be disqualified from being a trustee. When you take on the appointment, you have to actually be appointed by the masters, so you have to put a motivation as to why you should be a trustee. So they can also look at it and say, well, firstly, if you've got 3 trustees and you're trying to appoint another family member as a trustee, they'll say, look, no, we want an independent trustee. So there are non-malicious reasons as well as to why you might be not be appointed, but generally it's really your capacity to act rationally and will dictate.
And what if that changes when you are already a trustee?
Well, then the trustee deed will actually provide that you need to be removed as a trustee. And there'll be a process to reappoint or to appoint another trustee in your place. So you as soon as you, and the problem is that how do you know? Like, I think sequestration is quite easy because that is black and white. But when you've got a person who is just slowly making more and more rational decisions, and might be 90, and you like him a lot, but you really should try and get him off as a trustee, that becomes a little bit more delicate. And
right.
But so there's in those cases you need one of the trustees to take the plunge and actually start the process of moving the person off.
Right. And it sounds like the master is quite fair and open to mediate if need be. So you, as a beneficiary, even you could approach the master and ask for assistance, right?
100%. In my experience, the master's office is it's often I think if you went there, it often looks like there's chaos, and I don't know if it's always organized chaos, but there's a lot of chaos that is in most master's office. But personally, I've always found that approaches to the master's office actually there are always people who try and help. So I think in any organization there's always good and bad, but I've always found that you can find good people in the master's office.
That's good to know. Okay, so here's another question, interesting one. In 1999, we set up a family trust and registered it with a law firm, but it has remained unused. Are there any legal consequences for not using it beyond the initial registration with an attorney? Is it possible to ignore it, or is it a formal closure necessary? It is essentially dormant. So I think the same applies, but for you to answer.
I think they're fairly benign, these trusts, because they really haven't. There's not your mischief is not much. If you look, you formed a trust, and then it's a bit like Fields of Dreams. That in my case, that's what I did. I formed a trust, and I thought it would be filled up with lots of money. And but when that didn't happen, you still got your 100 rand that you put in the trust. And I think it really is. I think what you'll find is the trust is set up with a nominal amount that you've agreed to set up, that you agreed to look after. I think if you look at it and say, well, we'll terminate this trust and distribute the 100 rand which you've agreed to look after to the beneficiaries, it's a good thing to do. But if you look, there's no such thing as really a dormant trust, because there is always the nominal amount that you're supposed to be looking after. So if what happens, the founder sets up the trust, he says, here's 100 rand, please look after it for me. That's your duty, is to look after the 100 rand. It's a bit like the parable of the talent. If you put it under your bed and you never made it grow, you still have to give back the talent of 100 rand. So I think my thoughts is you haven't done much wrong, but just go to bed and sleep nicely by getting rid of that trust.
It still needs to be terminated.
It still needs to be terminated.
Okay.
Yeah, and I think maybe to add to that as well is, it's an easy closure. We're not going to take a sledgehammer to a peanut. It really looks like it's a benign type of document. There shouldn't be a lot of paperwork to chase. it's something we can work with and close down relatively inexpensively and quickly.
Okay, great. So now you know where to go. And that's, so I think that, sure. Sorry, there's one question and then we'll just chat about that a bit more. So how difficult is it? Thanks, Ashton Naju, for your question. How difficult is it to move assets from a personal capacity to a trust? So is that to an existing trust, or would you have to formulate a trust? I suppose there's the two different scenarios, right?
Well, there's really two ways of getting money into a trust. You can either donate it into the trust, or you can lend the money to the trust and say, look, you can have this money, and you enter into a loan agreement. So those are the two main reasons, or the main ways that money gets into the trust. A donation triggers donations tax. If it's more than 100,000 rand in a year, you're going to have donations tax on donations into the trust. It also triggers a whole lot of possible deemed accrual provisions in Section 7 of the Act, of the Income Tax Act. So if you donate money into the trust, then you have to come and see us, because there are going to be lots of complicated tax consequences to that donation. If you lend the money into the trust, you can also, the good thing is there's also complicated tax implications attached to lending money to a trust. So getting money into a trust is slightly, it comes with tax challenges, but generally you'll find that people donate or lend.
Okay, but what if Ashton is a trustee of the trust? Then he can move assets in and out.
Well, only if it's to the best advantage of the beneficiary.
Okay.
So if you look at it, the reason why he's putting money in and out of the trust needs to be analyzed, because if the beneficiaries are not being benefited by it, then he's actually not acting in the best interest of the trust or the beneficiaries, and could be in breach of his fiduciary duty. So it's you don't have carte blanche to do whatever you like. You've got to always put it under the umbrella of looking at as to why we're doing it, and is it going to be to the best advantage of the beneficiaries.
Okay, so I think, Ashton, you need to give Brian a call at LEMS. Okay,
No,
I think so. There's no simple answer to that one.
No, this is where trusts are slightly problematic, is that the law, especially the tax law relating to trust, isn't easy. It's fairly complicated, and the Tax Act is littered with a whole lot of tax legislation that is there to regulate trusts. So it's easy to get it wrong, put it that way.
Right. And I think there's no one size fits all. So every situation seems totally different and with so many variables, right? So consultation is a good idea to start.
No, 100%. I'll give you an example. How many times, if you look at a person who, if you've put money into a trust, so you've now donated 100,000 rand into the trust makes 10,000 rands worth of interest, and you say, well, I'm going to give that to my child who's 10 years old, because his taxable income is virtually nothing, and if I distribute that 10,000 to him, he won't have to pay tax. Now, that I've seen done, but people don't realize that there's, under Section 7, there's a deeming provision that says that 10,000 rand is deemed to be the person who donated the money into the trust to start with. So it's those type of provisions that are often overlooked, and sometimes overlooked by the taxpayer and by SARS, but at some stage you've got a high chance of being caught. And it's those type of things that we just need to actually make sure that you don't get wrong.
Okay. I've got another question from Karen, both attorneys. What are the implications of transferring shares of a property owning company to a trust?
Well, it depends on how we do the transfer, because for instance, if if you've got if a trust has got an asset, and this is and the trustees say, look, we don't want that asset in the trust, we'd rather have it in a company. There are provisions in the Act that allows that asset to be moved into the company, and the company can then issue the shares to the trust, and there will be very little tax consequences to either party, either the company or the trust. But if a trust buys shares from a third party, well, then it will simply own an asset being shares. So a trust has got the ability to acquire assets and to acquire shares. Just one of the things you've got to bear in mind is that in the trust deed, you have to actually specify what the objectives and what the trust can and can't do, what the trustees can and can't do. So you can't, it needs to be specified in the trust deed that the trustees can buy up assets, including shares. If it doesn't say that, the trust can't do it. So the trust deed is a driving instrument that must be carefully looked at, because it can only do what the trustee tells it can do. So,
Right.
to acquire the shares, the first step would be look at the trust deed and see if the company or the trust can actually acquire shares. If it doesn't say it can acquire shares, well, then it can't.
And what did so every trust deed is also different.
Trust deeds are unique. They're unique contracts.
Unique to that trust.
Yeah, so
Wow,
because it's
okay.
it's a contract between the founder and the trustee. So they all have got there's not a one stop shop. It's
wow.
everyone's different.
Okay. Okay, guys, thanks for tonight. I think you've answered some amazing questions, and thanks to everybody for your questions.
Thank you.
Yeah, some great questions. We're going to continue with another subject, trusts and trustees, but I'm not going to tell you about that now because we're actually out of time. But thank you so much, Brian, and thank you so much, Alan. I think it's been a great start to our webinar series, and please look out for the next one. We will be doing some marketing around that. And for tonight, guys, that's a wrap from Angela from Business Sense. Good night.
Good night.
Audio Jungle.